Hello. What's up?
Pinaki sir, you can mute and unmute yourself.
Yeah. I can do.
Yeah.
What's up? Can you test quickly?
Yeah, sure.
Go to presentation mode and just scroll down. Okay. Scroll down. Okay, it is working. Good.
Sir, you know, in your share options, there is a more option will be there.
Okay.
Disallow the annotations. Just see 3 number or 4 number point.
Okay.
Annotation.
More is in the zoom more. Zoom.
Annotate, huh? So what I should do?
Just see what other is mentioned over here.
Mouse, select, text, draw.
No. It is a annotation is allowed or not allowed. More in more options.
More.
The last.
Optimize share.
Top of your screen. There is a more options.
So more I have clicked over there.
Third or fourth point. What are the names?
Okay, disable participant
Annotations.
Huh. Okay.
So it is already done, I think.
Yeah.
Disable. You just click on it.
I've clicked it. Yeah.
So I cannot write down anything, right?
Correct.
That's it. Pinaki sir, anyone from your team now in the list, so I can make co-host him.
No one is till now. এখনো আসেনি যদি প্রকাশ দেবরা গৌরব গুপ্তা আসে তাহলে you can make.
Okay. You just tell me, so I will be co-host them.
আর দুটো নাম দেখে নিও, গৌরব গুপ্তা আর হচ্ছে প্রকাশ দেবরা।
ওকে, আমি দেখে নেব।
বলো। তোমার কোনো কমেন্ট? না, আমি একটা জিনিস আপনাকেও পাঠিয়েছি, আমি লিখেছি যে এক্সামের টাইমটা দেখে নিন। ফোর্থ সেমিস্টারের এক্সামটা তো কবে হবে? জুন মাসে হয়। সরি, ফোর্থ সেম, হ্যাঁ। তো ইউনিভার্সিটি একটা কোনো ডাইরেকশন দিচ্ছে না, কি একটা কোনো ছিল?
Usha will going to talk on the patent session 1. Tomorrow he will going to continue that one again. So we'll follow the same rule as on yesterday. If you have any questions, you raise your hand at the time when the speaker will ask for the question. Before that, please be in mute and note down all your questions. Even if you can in the chat, you can put your questions. We'll record all the questions and we'll try to give the answers to all the questions. Thank you. Over to Usha. Usha, can you take forward?
Yeah, thank you, Pinaki. Am I audible?
Yes.
Yes, sir.
You are audible.
Okay, great.
You are
Okay.
audible. Absolutely.
Thanks everyone for joining the session. So as Pinakita told all of you, I am Utsav Banerjee. So presently I'm working for Cognizant. I'm a patent attorney over there. I have worked in companies like Samsung, TCS, ARC, and similar companies before. So that's in a very nutshell what I have done so far. So today's session we would be discussing only on patents. But in the Q&A section or the question and answer sections, you can ask me any question regarding yesterday's session. If you have any doubt on anything on intellectual property, you can ask. And at the same time, you can ask anything on today's session, that is the first part of the patent. So the patent, because it's so much significant in technological domain, it's one of the most important form of intellectual property. So we have decided to break it down into two sessions. So today's session, we would be talking more about, the patentability and what is a patent and similar stuff. Tomorrow's session, we would be basically discussing on how to understand, what a patent document looks like, what is the anatomy of a patent. And if you are an inventor, if you want to file a patent, what are the things that you should do and what are things you should not do, and how to construe a patent document once it's drafted by the patent attorney. Because usually in across the world, specifically patent attorneys draft the patent application, and as an inventor you need to understand like what that person has drafted and whether it truly reflects your invention or not. So tomorrow's session will be basically on that part. Okay, so agenda for today's session. So we will be starting with the definition part. So definition, we would be, just taking a bit, step back. We would discuss a bit on intellectual property. And on that same premise, we would define what is a patent. Then what are the steps involved in, from idea generation to a patent grant. Then we have to understand what is a prior art. And the last part is what are the criteria for patentability. So if you have an idea, if you have an innovation, if you have an invention, how would you understand that whether it's patentable or not? So let's start with the session 1. So in yesterday's session, we have learned that, properties of two types, basically tangible and intangible. The intangible part is where this intellectual property whole domain lies in. So anything that is created out of human intellect is an intellectual property. So what human brain can create, it can create inventions, it can create a literary work. So you can write a good poem or a story. You can write songs, you can write softwares, you can start a business, you can develop a patent. All of this can be, created by our human mind. And all of them are, very valuable in today's world. So they are property, but because they are of various types, they cannot be protected by the same law or the same form of intellectual property. So a song written by A.R. Rahman and the electric bulb invented by Edison cannot be protected by the same form of intellectual property. So that's why we have various types of intellectual property, which we have learned already yesterday. Uh, in today's session, we will be specifically talking about the industrial IP rights, and within that, a particular type of IP, that is patents. So we are not talking about the other forms of IP today. Okay, so what is a patent? So patent is basically, it's a limited right. It's granted by the state to the inventor. So if you are an inventor, the state gives you this right. And what is it? Like you have an invention, you have to disclose that invention to the state or to the government. Government would check and see that whether it's protectable or not. If it is protectable, then you get a right for 20 years to exclude anyone else from practicing that invention. So what is what is practicing means? It means manufacturing, using, selling, offering for sale, or import. So if you have a patent over a particular invention, then only you would have these rights, and you can actually prevent others from doing this. So a patent right is granted for 20 years. So it's as a form of intellectual property, its protection is for 20 years. There are other forms of intellectual property which gives much higher term of protection, but for technology and for innovation and for inventions, whenever you hear these terms, the only form of IP that is relevant for us is patents. Okay. So patent rights are territorial in nature. So if you file a patent in US, it would be enforceable only in US. So somebody else would be free to use it in India or anywhere else in the world. So if you file a patent only in India, it's applicable only in India. So, and there is nothing called global patent. Like there is no single authority which can, where I apply for a patent and I get a patent that is valid worldwide. No, that's not happening. So there are certain international bodies through which we can make our filing, but again, we have to reach out to individual countries to get our patent protection. So it's a costly game. It's not like, unlike copyright or some other forms of IP where there's a provision to get a global copyright or protection across the world. This is not allowed for patent. Okay. So what are the subject matter for patent? What is patentable? So it is something like, it has to be a process, a machine, an article of manufacture, and composition of matter. So these are the 4 categories of subject matter which is protected by a patent. This is under the US law. Indian law is also in the similar lines. All of these things are also protected by patent. So it has to be a process. So if you have invented a new process, that is patentable. You have invented a new machine. So machine does not always mean it has to be a mechanical machine. It can be an electronic machine. It can be a software enabled distributed system, something like that. That is also protected as a machine. Then articles of manufacture, things that can be manufactured. So those are protected by patents, and composition of matter. So all of chemical inventions basically go into this domain, composition of matter. So what are not patentable? Once we have understood what is patentable, what is not patentable is pure software is not patentable. Abstract ideas are not patentable. Mathematical models are not patentable. Scientific formulas and laws of nature are not patentable. So these things are under restricted or prohibited category. So these are not patentable. So as an inventor, what should be the easiest touchstone for you to understand that what is the subject matter? Or someone comes to you, a student comes to you, if you're a professor, student comes to you saying that, sir, I have developed this. How should I protect this? Is this patentable? Is it copyrightable? Is it trademarkable? What form of IP is applicable for it? So whenever such problems come to you, the single touchstone that you can always think about, so there has to be a problem, a technological or an industry problem, and the invention or whatever you have developed should be solving that in a technological means. So if that is satisfied, then that is specifically a subject matter of patent. So there has to be a problem. So a well-defined problem. Problem can be anything. It can be an existing business problem, a technological problem. Right now, we do not have a vaccine for COVID treatment, so that is a problem. We do not have a medicine for treating COVID. That is a problem. So the problem has to be well-defined, and the solution that I have developed for that particular problem has to be technological in nature. It cannot be business. So like I have a store, a departmental store, and due to COVID, people are not coming to my store. They're opting for home delivery, but I want people to come to my store, and I have all technological means to ensure that people do not get infected by COVID. So my problem over here is business problem because I'm not getting enough sales. Now, what can be a solution to that? A solution can be I can give heavy discounts on my products. Yes, that's a solution, but the solution is not technological in nature. It's business in nature. So you cannot file a patent on that. So how can you file a patent on this? So what you can do is you can have a technological angle to it. So maybe you have an application that the user installs on his mobile phone, and your store is a smart store wherein the application is running in a server, and it has got various sensors across your store. Whenever a person comes into the store, your store knows that who the particular person is, what is his buying history, what is his what are the things he likes, and in real time you suggest him certain objects or products which he can buy, and those notifications are sent to his mobile phone. Not only that, he is directed to the location where this product would be available. If you have a big departmental store, you get a Google map or something which navigates you to that location, and you give real-time discounts on that and a dynamic discounting system. Overall, this total system can be a subject matter of a patent. Okay, so always keep this in mind. There has to be a problem. Problem can be business or technological in nature, but the solution to that problem has to be technological in nature. Only then you can get a patent on it. So now I have an idea. So as a professor or a student, you have an idea, and you feel that is valuable. It's solving a problem, and it can be in any field. It can be mechanical, it can be civil, it can be computer science, it can be electronics, anything. So you have a problem solution approach. You have a problem and you have a valuable solution to it. So what are the steps that are involved to get a patent? So first is this is a very standard process across the industry or even in academia. So there is a form that is called invention disclosure form. So these forms are usually drafted by the attorneys. This form would have a set of questionnaires that you need to answer as an inventor. So there would be a number of questions to explicitly bring out what is the problem and what is the solution that are developed, how that solution is different from others, or people who have already developed it, how is it different from them. So that form, you have to fill that form up and you have to send it back to the attorney. The attorney would check whether it's patentable. So I would talk about, is all problem solution patentable? The answer is no. So there are certain benchmarks or certain checks that it has to go through to become finally a patent. So those checks would be done by the patent attorney. Then he would draft a patent application. The inventor needs to review it. Then the patent application is submitted in the patent office. Over here, it's very pertinent to say that or state that a patent application is basically a techno-legal document. So it would have huge amount of technology involved in it, which brings out the basic invention that you have done. But such language has to be brought in which is legally rich. So there are certain stipulated statutory language that has to be used for drafting a patent. So the application would be drafted by the attorney in that particular language. And as an inventor, you need to understand that language. Otherwise, there might be a gap between your invention or the patent application that has been drafted by the attorney. Okay. Now, once the patent application is filed, in the patent office, in the respective patent office, wherever you want to protect it, it lies idle over there for 18 months. Nothing happens. For 18 months, it lies idle in that patent office. And after 18 months, you have to file a request for examination and you have to give certain fees to the government. So once you've paid that money, government has designated officers who are called patent examiners. They would start reviewing your application. Okay. So they would do prior art searches. We would talk about prior art search, what is it and why it is so much relevant for patenting. And he would raise office actions saying that why he would not grant a patent or why he would grant a patent. And then you have to reply to those office actions, and this is a iterative process, once or twice or thrice. After that, what comes out of it is a grant or a rejection. Okay. So typically in US, it takes 2 to 3 years to get a patent grant. In India, previously it was almost 5 to 6 years. Now it has reduced a bit. So we are getting patent grants in maybe 3 years also. We have seen patents getting granted within 3 years. So that is the lag period we would always have. So keep that in mind whenever you are planning commercialization, or you are filing a patent, you want to sell it to someone else. Keep that in mind. A patent would take at least 3 years in India to get a grant. So I know that till now there will be huge number of questions. So I would take the questions after the session. So as Pinakita told you earlier, please keep a tab of all your questions. We would take it one by one after the session. So it's very important for us to understand what is a prior art, because this basically defines what is patentable and what is not. So again, the same question, a student comes to you as a professor, or maybe as a professor, you have developed something. You have developed a new solution to an existing problem. Is it patentable? The answer might be yes, might be no, because as you understand, it's intellectual property right. That is, government is protecting your intellect or creation of your brain. So first thing that is very important for you to understand is that it should be something that is very unique. No one before you must have done it. Okay, so to understand that no one before you have done the same thing, you have to understand what is a prior art. So prior art means the date when you are inventing it and submitting it to the patent office. All the information that is available in the public domain is a prior art for your invention. So it can be a video recording, it can be a newspaper or a magazine article, it can be other speeches, it can be journal papers, it can be patents, anything that is existing in public domain before the date when you are submitting your invention to the patent office is prior art for your invention. So if it is anywhere in the world, it's a prior art. So even an ancient Indian scripture, or maybe something written in Hebrew, can also be a prior art for your invention if it is relevant. Okay. So it can be in any language, it can be in any country, it can be anywhere in the world. Specifically for US, they have specific databases wherein they search for these prior arts, and that practice has percolated now to across all the patent offices. So whenever you file a patent in Indian Patent Office or any other patent office, the patent examiner would check on these prior arts to see how your invention is different from these prior arts. If your invention is same as that of the prior art, then you would not get a patent. Okay. So prior arts are of very paramount importance when it comes to getting a patent granted. So searching this prior art, so as you can understand, patenting is not a recent concept, wherein Google search and electronic search for data is a relatively new concept, maybe 20-30 years, not more than that. So previous to that, patent offices had a very tough job. So they had to keep all documents and everything in hard copy format in a library within this patent office. And whenever a new invention is to come, they had to search manually and physically through all of those documents to understand what is a prior art relevant for that particular invention, or what is already known in the public about that field of invention. So it was a very tedious job. So now Of course, we have electronic searching systems. We can parse through data, we can compare through data. It's become very easy for us. And there are a number of databases, both publicly available free of cost or paid, through which we can search to understand what are the relevant products which is applicable to my invention or to my I would say innovation. So we have a number of such databases. So certain free databases which you can always go and look at Google Patents. You can go to free patents online. So you can basically go to Google and search free patents online or Google Patents, and over there in the search field you can type about your invention, and you would see all the relevant patents that has been filed before you in that particular domain. So it's something that you can, as an inventor, do it and change your invention or modify your invention accordingly, so that there's a probability that you would get a patent granted. Okay. So now that we have understood, so we would now start understanding how to compare the prior art to your invention. So why this is relevant? Because suppose a prior art talks about I have there was a there is an industry problem. I have developed a process to solve that problem. The process has 4 steps: A, B, C, and D. And in one prior art, I find that there are 3 steps mentioned: A, B, and C. The D part is not missing. So can I get a patent? Or like, is how much different should my invention be from the prior art to get it patented? So to understand that, we have to understand the prior art concept very well, and the subject matter that I am trying to patent has to be within the technical character domain. So it cannot be non-technical in nature. That I have already told. So if any part of my subject matter that I am claiming to be my patent, or I want to get a patent protection on it, or I say that this is something that I have invented, it has to have a technical character in nature. It cannot be of non-technical nature. So if I have, then I have passed through the first test. So there are 3 or 4 tests that your invention should pass through to get it patented. The first test is the technical character or the subject matter eligibility. So this is the first test. So we will talk about all the tests one by one. This would help you to understand that if you have developed something, whether it's patentable. So now that the subject matter is technical in nature, that is, there's a problem and I have solved it using a technological means. So the subject matter is cleared. Next comes the trinity, the golden trinity, or three important pillars of patent. They are novelty, non-obviousness, and utility. So let us understand them one by one. So I have a raw idea. It has to pass through all of these hurdles to get patented. So whenever you submit an invention disclosure form depicting your invention, the in-house attorney or the patent attorney would basically search through these 3 things to understand whether a patent can be filed or not. And then based on his search, he would draft it. Then when your patent is in the patent office would again search based on these 3 pillars to understand if they can give you a patent or not. So it's very important for you to understand these 3 hurdles that your idea must pass through to get a patent. So first is novelty or newness. So this is something that is very relevant. So if you are claiming something new, if you are saying that this is my invention and I need to get a patent on it, it has to be new. So no one before you must have done it, correct? So that is the first test, that is the novelty. So what the novelty says, it says that if your idea has 2 steps, suppose it's a process patent, it has got 2 steps, X and Y. In one single prior art document, if both X and Y are mentioned, then your invention is not novel. You would not get a patent on it. So this is pretty obvious, because if someone else before you have described your invention in one single document, why would the government give you a patent? The government should give a patent to that person if that person had applied. Or if it is in public domain, no one would get a patent on it. So this is the first test. So the touchstone for this novelty test is all the features that is relevant for your invention has to be present in one single prior art document. If there are multiple prior art documents, which basically in combination, speaks about your invention, then they do not destroy the novelty of your invention. Your invention still remains novel. This is the first test. Then comes the next test. Next test is the non-obviousness test. So it says that suppose there is a product in the market which has got which is A. There is another product in the market which is B. Now, I being an inventor, I see that A and B brought together can serve new purposes, can be more efficient, can have more efficacy. So what I do, I combine A and B. A is a pre-existing product, B is a pre-existing product. And when I apply for the patent, I say that, see, in no single prior art, A and B both are mentioned. So there are prior arts which mention A, there are prior arts which mention B, but not a single document which mentions both A and B. So I should get a patent. The patent examiner would say yes, partially true. So your invention is novel because no single prior art talks about both A and B, but it's obvious. Why? So the test is, if my invention is a mere combination of known prior arts and a person having ordinary skill in that particular art or in that particular domain of technology feels that combination of such prior arts is obvious, then you do not get a patent. So this again is this test is also very realistic. Just think in the hindsight that there are hundreds and thousands and millions of products and processes available in the market. Mere combination, if I start doing off all of it, there would be billions and billions of patents. So that should not be allowed. So somewhere you have to show that A and B, combination of A and B was non-obvious. It was not so easy because people could not do it because of this reason. So there were certain issues in that, in combination of A and B, and I have overcome that issue. Only then you can pass through the non-obviousness test. Okay. So now we have understood non-obviousness. The third test is utility. So utility means your invention should have an industrial application or should have a utility in that. So you cannot file frivolous inventions. So example, like if you develop a system for discovering aliens camouflaged in a human crowd. Okay, so there are patents on that. People have filed patents on that. So there's a huge crowd, say in our Esplanade area, and you are suspecting that there might be some aliens hidden within that cloud, within that crowd. So how would you find out that who is a human being and who is an alien? So they have filed a patent on that, and the parent office have rejected it, saying that this does not have any utility because first of all, science as of now does not know existence of aliens, and that's why such inventions would not be granted. So do not think about utility too much, because whatever we do in our labs, whatever research that we do, whatever inventions that we do in our real life always has a utility. Otherwise, we would not be working on in that particular domain. So that is absolutely explicit understanding. Okay. So now I will be going to the test obviousness to understand more about obviousness, because in the previous slide, as I told you, novelty is very clear. It's very easy to understand novelty. My invention should have some delta or some difference over and above existing prior art, one single prior art, and then I have a novelty. So there is no doubt on that. But how to understand what is obvious and what is not obvious? So I will bring an example. And utility is again very explicit and very easy to understand. So I don't think you would have any issue in that. Okay. So let us understand obviousness. This is a very interesting case study. So now suppose there is a pencil, there is eraser. Both are very useful objects. But you suddenly realize that a pencil without an eraser has limited use. An eraser without a pencil has got no use. So, why not combine them? So you take a rubber band, you tie the rubber on top of the pencil, and you say that, see, I have a new object or I have a new product. So I should get a patent on this. Why? Because in one single prior art eraser was mentioned, in one single prior art pencil was mentioned, but there is no prior art which basically has both of this together. So I should get a patent. And this was an explicit problem or exact problem that human beings faced during the First World War, because there was bunker warfare going on. And in the bunkers, like the army and the army personnel had to take regular notes. They used to use pencil for that. And then keeping an eraser and a pencil separately was a difficult task for them. So they wanted something which has both of them. So you take a rubber band and you tie it up, and you say that not a single prior art mentions both of these together, so I should get a patent. Then the examiner would say that pencil is known, eraser is known, rubber band is also known, and a person having ordinary skill in this art, maybe a mechanical engineer or someone, would use a rubber band for tying two objects. So that is also known, that rubber band is used for tying two objects. So this is an obvious. So this is invention is obvious. A person having ordinary skill in the art would have used a rubber band to tie a eraser on top of the pencil. So you cannot get a patent on this. So it would be rejected on obviousness. But there was a patent on this subject matter too. So how the patent was obtained? So this was a patent during the First World War, and we have all used such pencils. Okay, so it is something like you take the pencil, you make the eraser cylindrical in shape, you make a metal cylinder, you insert it on top of the pencil, you make the eraser cylindrical in shape, and you insert it at the top of the pencil. So you can get a patent on this, and there was a patent that was granted on this particular subject matter. So a pencil is known, a eraser is known, but metal encapsulation for combining both of these two things in this way and increasing the efficacy of the substance, because on one side you can write, and similarly you can just rotate the pencil, and on through the other end you can basically erase. So there was a patent granted on this, and this was extensively used by the American soldiers during the First World War. So this is what obviousness test is in a nutshell. So I understand that there would be a huge number of questions today on patent. So I have a couple of very good interesting stories on patents. So I can talk about it in my later session, or in this session itself if I get some time. So I open the house for questions till now. So patentability criteria, patent, subject matter, and anything on intellectual property, please go ahead and ask questions. If some time is left after the question and answer session, I would talk about few interesting stories about patents.
Okay, Mr. Palash, you can ask your question.
Yes, sir.
Please go ahead.
Good morning, everybody. I am Dr. Palaspal, Principal of Dumka Engineering College. I have some question to Utsav Banerjee. And see, the question is that, as Utsav has told, basically there are some prior art and new art are there. So, as for getting the patentable thing for novelty, actually how much implementation is needed, how much percentage of implementation is needed to get novelty from the prior art. Suppose to say if I go for design a new circuitry to get novelty, and this is absolutely novelty, so for that case how much percentage of changes is needed to get a new art from prior art. And another thing, Utsav supposed to say, if pass out from 2006,
Yes.
in the year
So
2006 from so this is for us. Yes.
so we were batchmates. Yeah. Good. Okay. Okay. Thanks, Balash. So I would take up your question. So first question that I can refer from your overall query was implementation details. So Patent Act does not have, explicit requirement on, the working prototype or a proof of concept or a pilot, something needs to be done. There is a provision wherein the examiner might ask for a prototype from you, but in my long career, I have never seen any examiner ask for it. So ideas as thin as air can be patented. So you have to just provide the implementation details in your patent application. So the patent application should state your invention in such detail so that a person having ordinary skill in the art can practice your invention by reading your patent. So, that's why in specifically in corporate world, we do not wait for prototyping to happen for file patents, because time over here is very important, and we know that a number of our competitors are working on the same field. So whoever files the patent first gets it. So that is another very important tenet of patenting. Uh, whoever is first to file gets it. So whenever we have an idea and we see that there is a relatively high chance of it getting successful or getting implemented, we definitely file a patent on it. But obviously there is provision under the law wherein the examiner can ask for a working prototype. Suppose you file an invention for time machine, okay? So such drastic inventions, the examiner would definitely ask for a prototype and do a time travel to ensure it works. Does not require any prototype. So that is the first question. First part of your question, I believe I could have answered. Second part is how much novelty it has to be. So novelty test is very absolute in nature. So any delta that you develop on top of existing product is sufficient. But how much delta it has to be, actually the law does not define it. But the law states that if you have difference with the product, and the difference can be anything, very, very minuscule difference, even if you have that, then you can basically overthrow or bypass the novelty. But there are certain case laws in US which states that if the add invention, it can still be rejected. But such philosophy or such jurisprudence does not apply in India. In India, what would happen is if your invention has got very minuscule difference with prior art, you would pass through the novelty test, but you might fail in the obviousness test, wherein the examiner would say that the minuscule difference that you have brought in or the delta that you have developed on top of prior art is so less that it's very obvious to a person scaling. Hope I could answer your question.
Yeah, thank you, sir. So, Mr. Pal, Dr. Pal, if you have any questions, you can raise your hand again. I will put you back. Mr. Sarup Das, you can now ask the question.
Sir, hello.
Hello.
Good morning, sir. Is it audible?
Yes.
Good morning, sir. Is it audible?
Audible. Please go ahead.
Yes.
Sir, my question is. Sir, my question is that you have given example of a pencil and eraser with a rubber band that is can be patented. But sir, already those things are existing. Suppose instead of this, any existing thing like machine parts, two machine parts already existing, can we suppose somebody is filing patent by combining those two things? But the previously it was patented, then he will be in problem, no? Because already these are existing. How can we combine and say that it can be patented?
Okay. Got your question. So So we have to understand the total patent system across the world is incremental in nature. And the basic philosophy or jurisprudence behind granting a patent is public knowledge should get enriched. So whenever I patent something, I basically disclose the detailed working of it to the public. Public and large can do more research on it and develop more inventions on top of it and file more patents on top of it. So that's why the patent system is always incremental in nature. Like I would give you a very interesting example. So whenever we say who invented electric bulb, most of you would say it's Thomas Alva Edison. But Thomas Alva Edison did not invent electric bulb. Electric bulb was invented almost 10 to 12 years before even Edison started working on electric bulb. So all those electric bulbs had problem with it. So the basic structure of the electric bulb, that is having a glass encapsulation and inside it having a filament and passing electricity through it to generate luminescence. So that was the basic tenet of the patent on electric bulb. But all such electric bulbs had problem. They had tried various types of hours. That was the maximum that it could last, and so they were not commercially viable. So you cannot have an electric bulb which lasts for 2 hours, and each and every 2 hours you have to keep on changing the bulb. It's not possible. So what Thomas Alva Edison did, he basically invented a filament, a tungsten filament, which basically in those days it could run for I think 12 or 14 days. So that was a huge problem that he solved, and electric bulbs became economically viable. But does that mean that Thomas Alva Edison can manufacture an electric bulb and sell in the market? Answer is no, because patents, the base patents on electric bulb was already owned by some other people, and there were almost 30 more patents that were on electric bulb which needs to be used for getting a bulb working. So Edison had to buy out all those patents before he could start launching his electric bulb commercial. So now it's very interesting or important for us to know that if two machine parts are already existing, and if I am merely combining them to file a new patent, the question would be whether it's obvious or not. And there are various tests, it's across the world, to understand whether it's something is obvious or not. So first is the new combination that you make, does it have a huge economical implication? Second is like the combination that you make, why was it not done by anyone before you? Third is the combination, does it show huge amount of efficacy change, huge amount of effectiveness change, efficiency change? If all of these things can be yes, then you can pass through the obeisance. So these three touchstones you can believe in or you can refer to whenever you feel that I am combining these two things. Why people before me could not do it? Is it a mere combination, just admixture? Is it economically very significant, or was there any specific technological or technical problem in combining those two things? If I can answer these questions, then we can bypass the obviousness.
Sir, but sir, before combining, is it necessary to purchase these patents from the existing?
Yes. So, combination and doing, see, it's the patent law basically gives certain rights to the patentees or the patent owners. So, any right to use it, commercialize it, offer it for sale or import, export, all those things are given to him. So if you are merely combining two new or two known patents, file a new patent on it, till that point of time, it's absolutely fine. You can always file patents, get patent granted, absolutely fine. The moment you do any of those activities which are prohibited under this patent act, you have to take license or you have to buy out those patents. So as long as you do research and development in your lab on it, to some extent you are protected, not absolutely, but to some extent. But the moment you go ahead and sell it, generate money out of it, or give it to the public, start manufacturing it, you have to take license from all pre-existing patents. If your product or process basically has or performs all of the steps that has been mentioned in those patents. So we would talk about infringement, patent infringement in tomorrow's session. So wherein you would see that what exactly constitutes a patent infringement and when I need to take a license of a patent for using it.
Okay. Thank you very much for your answer, sir.
Okay, Utsav, is there some more things that you want to present today?
Yeah, sure.
Okay,
So,
because there is a 4 more people on the queue to ask questions.
No, I think I would take the questions. I would keep last 5 minutes for a short story.
Okay, so you want to take your questions now?
Yes.
Okay, Mr. Mukherjee, Kaushik Mukherjee, go ahead and please ask your question. Only one question because of the time constraint.
Hello, am I audible?
Yes, yeah, sure.
Good morning to everybody. My question is, why patent application is published after 18 months of priority date? Is there any reason for that, for any verification of the activities or any other things? The 18-month gap between priority date and patent application publication, there is an 18-month gap. What is the reason, logic behind that?
Okay, so basically there are two logics. First is this 18-month statutory, I would say sleeping period, the period when your invention or your patent application sleeps, basically is a time that is given to the inventor himself, so that if necessary, he can make more changes in the patent application and submit it to the patent. So suppose today I have filed a patent, suppose on a vaccine for corona or COVID-19. Okay, vaccine for curing or preventing COVID. And there are 18 or 20 more companies in the world working on the same domain. So I see that there is a reasonable chance of success. So of my vaccine, I immediately file a patent on it. Now I have 18 months. 18 months it is not published in the public domain. I do more experimentations on it. And then suddenly I find that, if I do some minor modifications in it, the efficacy of that particular vaccine increases tenfold. So now I can go back to the patent office, withdraw my application and file another new application or make changes to it. So that is the first reason, given to the inventors 18 months statutory period during which you can make changes in your application if necessary. And there are provisions wherein you can pay extra money and get your patent published much sooner than that. So there is a provision for early publication under Indian Patent Act, US Patent Act, and all other patent acts. And that is a way through which government gets more money from the inventors to ensure that your patent is published before that 18 months deadline.
Okay, thank you. So the next person is Mrs. Arpita Chakraborty. Please go ahead.
Good morning, everybody. My question is, what are the search methodology, that is search techniques for prior acts?
Okay, good question. Very good question. So this is something, the moment you become a patent attorney, the first things that you start learning. And this is very important even for the inventors to learn, because if you are filing for a patent or if you are inventing something new, there is no point in inventing a wheel again, correct? So a wheel has already been invented. You can develop something on top of it. Yeah.
Sorry to disturb you. Can you put off your PPT for time being during the questionnaire?
Yeah, sure.
Yeah.
Just one second. Yeah.
Yeah, please go.
Okay. Okay. So for the prior art searches, what you do is, or to understand what is relevant prior art for your particular invention, you basically first write down a paragraph or two on your invention, bringing out almost all the features of it, or you can even write bullet points of it. So maybe if your invention can be described in 5 or 7 bullets, you write it down in English language. And then you basically form search queries out of it. So using and, or, and other connectors, there are various types of connectors applicable for various different databases. You create search strings out of it and hit patent databases with those search strings. So as I told you, there are 2 or 3 very good free databases like Google Patents and Free Patents Online, wherein You can do searches free of cost, and there are paid databases like we use a lot of Thomson Innovation. We have Questel Orbit and other paid databases over there. The semantics vary from from database to database, and search queries and connectors vary from database to database. But more or less, the thumb rule is you break your invention into bullet points. For each below bullet points, you basically create search query using various connectors in it. Like I would give you an example. Your invention might be on a mobile phone, correct? So if you search mobile phone in this paid database, uh, any invention previous to your invention might have mentioned it as a cell phone, not a mobile phone. So your search would not show it because you have written mobile phone in it. So that's why you have to draft the query in a way wherein you cover all similar terms in that query. So you write cell phones, you write mobile communication, you write a number of other things, and you put and or something like this in between all of this and form search query. So forming a search query itself is a very important job. And maybe we can have another separate session because it would itself take a long amount of time to understand how to do a search query, how to draft it. But in any case, you can always reach out to your patent attorney for helping out how to do the search or do the search itself.
Okay. Okay. Thank you. Thank you.
Okay.
Okay, thank you. So the next question, Mr. Anusul Rahman, please go ahead and ask the question. Sorry, Mr. Rahman, can you please raise your hand again? Yeah, please go ahead.
Okay. Thank you. Good morning, everyone. I have a question. You have said that pure software cannot be patentable.
Correct.
Yes. And in the previous day, I have seen that algo of an mobile phone or a computer that can be patentable. And you have shown also an example where a business problem can be technology driven and that can be patentable. Can you draw a fine line which can be patentable, which cannot be in the software domain?
Okay, great. Very, very relevant question. So this question is a regular, I would say, problem for all patent attorneys who are working in software domain. So the law is very clear. Pure software or software per se or software as such is not patentable. So if I write a piece of code in a paper for doing something, that is not patentable. What is patentable is the functionality. So let us understand it through a very easy example. So these two are very famous case laws in US. So you can go and also search about it. So first is Gottschalk versus Benson. So in this case, what happened was all electronic devices in 1970s and 80s in US were operated through binary coded decimals, BCD. Okay, and if BCD is 11010011 something like this, and someone who is operating a microwave oven, if you show the temperature as 11010011, he would not understand. So it has to be showed in decimal. And conversion of binary to decimal in those days was very difficult. It was 7 to 8 steps involved, and all of these devices had very limited, computing power. So you change the temperature, you have to wait for 15 to 20 seconds for the temperature to show up on the display. So that was a problem. So what this person did, Gottschalk, what he did, he invented a new software which can convert or a process, whatever you call it, or algorithm, which can basically convert binary coded decimal to decimal in 2 steps, thereby reducing the processing time to only 5 seconds from 20 to 25 seconds. And he filed a patent. He said that, I have developed a software which basically, or I have developed a method or an algorithm, whatever you say, for converting binary to binary coded decimal to decimal number into 2 or 3 steps. The patent office rejected it, saying that no, this is pure mathematical formula. This is pure algorithm. This is a pure software. You cannot get a patent. If I give you a patent on it, then the problem is, even if a teacher gives a problem in a class test to a student for converting binary coded decimal to decimal, and he uses your method, he would be infringing on your patent. So that is not allowed. So that's why it was rejected. Next, how to understand then what algorithms or what mathematical formulas or what softwares are patentable. The next case is very important, which is Diamond versus Deere. So you can also go in the net and search about it. So it was about rubber manufacturing. So what happened in those days, rubber was manufactured by taking the sap or latex from rubber tree. You put it in a huge boiler. You add admixtures to it, sulfur and other chemicals to it. You close the lid of the boiler and you start heating it. After heating it for a certain period of time, with experience, you have to understand when to remove the heating and remove the lid of the particular boiler. If you remove the heating too early, the rubber is not formed and it does not have elasticity. If you remove the heating too late, the rubber is burnt, so it's charred and it's of no use. So in those days, there was a 20 to 30% loss of rubber due to burning. So that was the industry problem. So what this person did, Diamond. So what he did was, sorry, it was Deere. So the name of the person was Deere. So what he did was, he thought that what is happening inside that particular boiler can be governed by Arrhenius equation. Arrhenius equation is already known. So what he did was he put certain probes into that particular boiler. He took real-time readings of the temperature, pressure, and other state I would say figures. He put it into a computer. In the computer, he ran Arrhenius equation, a software based on it, and the software would automatically detect when the lid of this boiler needs to be opened and the heating has to be removed. And he filed a patent on a new method for rubber curing. He got a grant. Why? The examiner stated that the patent is not for Arrhenius equation. He is not trying to protect Arrhenius equation because it's already known. What he is doing, he is using Arrhenius equation for rubber curing. So it's a specific application of that particular algorithm. And he got a grant. So always keep these two things in mind, that if you are filing for, or if you are trying to protect an algorithm or a mathematical model or a formula, whatever be it, application of it in a particular field of technology, solving a particular problem, and the problem has to be obviously business or technological in nature, and having a software for implementing that algorithm running in a particular hardware system. So you have to develop hardware system around that. Okay, so you have to define comparators, you have to define some CPUs, you have to define various engines around that. So engines, AI engines, or some comparators, something like that. So you have to define a distributed system around that software. The software is running in that particular distributed system, solving a particular type of business problem, and it has to be narrowed down to a particular field of use. Then you can easily get a patent. But if you are trying to file a patent for adding two numbers, I'm saying like adding two imaginary numbers, maybe you cannot get a patent. That's for sure.
Okay, thank you. Yeah, now may I, Mr. Somnath Nag, you can please ask your question. Mr.
Good morning,
Somnath
sir.
Nag?
Sir,
Yeah.
one question. Hello.
Yeah.
Please go ahead.
Sir, when a inventor apply for patent for his inventory, then after that he modified his inventory, then he can apply fresh for the patent.
Yes. So now let us understand a scenario, the same COVID example I was giving. So I have filed a application for a COVID vaccine, and during the 18 months period, it's not yet published. It has not yet been published. And I come across a change in that vaccine which can make it 20 times more better. So two things that can be done is, first is, if the application has not yet been published, I can withdraw it, I can make changes in it, and I can refile it. Second is, if it is already been published and the patent grant and other process have started, what I can do is I can wait for the patent to get granted, and then I can file a patent of addition on top of it. So this is a new kind of patent wherein you have the base patent, you make minor changes in it to increase the efficacy of your existing patent, and you can file a patent of addition on top. So, I can file another patent, which is basically a patent of addition to the mother patent, and I can keep on filing n number of such application downstreams. So for each incremental increase of efficacy or maybe something better, than the previous patent, I can keep on filing more and more patent of addition. In US, we call it continuation or continuation application or continuation in part applications. But in Europe, we do not have any provision for any kind of patent of addition. So in Europe, you have to file another fresh application. And the problem is, if your present invention is merely incremental on the previous invention that you have filed, then your present invention can be obvious in light of the previous invention. That's why patent of addition, when you file patent of addition while doing the prior art search, the examiner would not consider your previous patent as obviousness destroying for your next invention or the patent of addition. But in Europe, you do not get it. So in Europe, it has to be another separate application. And if it is a mere, I would say, increment, it would fall.
Thank you, sir.
Okay, thank you.
Any more questions?
The next person is Mr. Sudipta Chakraborty. You can please go ahead and ask.
Hello.
Yeah, please.
Am I audible?
Yes, yes, please.
So myself, Sudipta Chakraborty. So my question is, can I apply for a patent if I have already published a paper on journal or reputed conference on the same idea or concept?
Okay. Very, very relevant question. The question again we face each and every day in our life. In Cognizant or in TCS, we used to face it. So let us have a thumb rule. The thumb rule is, do not publish without filing a patent. You should not publish anything which is patentable before filing a patent. Why? Because if you publish it, it becomes prior art. It is available in the search while you file when you file a patent in the prior art search. Your own publication can turn up and basically destroy your patent application. That is what the Indian law says. In US, that is the only country in the world which gives you a 12 months time. So if you publish it today, you have 12 months to file the patent. If you do not file within 12 months, then that publication becomes a prior art for your patent. But this 12 months window is not provided anywhere else in the world. So as a patent attorney, we always follow this thumb rule that first file a patent, then go ahead and publish it. Publication can be a journal publication. Publication can be showing a presentation to the to the scientific community, can be showing it to a client, whatever be it. Do not do that without filing a patent.
Okay, thank you. Now the next person, Mr. Saikad, Dr. Saikad Majumdar. Please go ahead.
Okay, thank you.
Yeah, am I audible?
Yeah,
yes, you are audible.
Actually, the questions that my co-colleague Sudipto Chakraborty have already raised the question, but I have specific two questions. One question is that for publishing journal paper, in a good journal paper, we need novelty, as well as for patent we need novelty. So what is the fine line of difference between these two novelties? And the second question is that for journal publication, if the reviewers reject the paper, then there are some comments from reviewer portion comes to me, and if it accepts, then also we get comment from reviewers. So in patent filing, the same procedure is maintained. I do not know. That is actually I am raising the question because in journal publications, the reviewer advised that if you change these equations to this or this experiment to that extent, then
Got your question, sir.
it will be publishable. But in patent filing, is there
Got
any
your question.
advice from the patent office?
Yes, yes, got your question, sir. So
Sorry, sir. And last question is that there are different sections. Actually, suppose in physics, there are different branches of physics, sub branches of physics, and electronics. There are different kinds of sub portions are there. Is the particular patent is going to that particular reviewer?
Correct. Got your question, sir. So first thing, novelty for paper publication and for patents, it's absolutely same. So do not worry on that part. So that's why we always suggest fill up invention disclosure form. After that, start writing the paper, because the invention disclosure form has questions which, if you answer, you get more clarity about your invention or your scientific discovery. And when you start writing a paper after that, you would see writing the paper becomes absolutely very easy. Even the vice versa is also applicable, wherein you write a paper and then you fill up the invention disclosure form. And while filling it up, you would get more information and you start more ideation, you start thinking in different line, and then you can also change the paper. So that is one part. As a thumb rule, we follow the process that we told you before publication. We obviously file a patent. That was your first question. So novelty part, no difference. Paper and patent, the touchstone is almost similar. Second is, would just like the journal, the review authorities or review body gives you various feedback. Same for patents. The examiner would basically review your patent application and raise objections on it based on prior arts and give you specific suggestions that why he is rejecting this patent and what are the changes that you need to make. So the attorney would make similar changes after discussing with you and resubmit it the patent or the patent application in the patent office after that. So that's a standard process, and the same thing happens just like a journal. Okay, and the third question, I forgot the third question. It was, sir, I forgot the third question. What was it?
Okay, I think
yes. Third question is that actually there are different subdomains of a particular domain.
Got it. I remember. So yeah, same as that of the same as that of journals. So in patent office, we have specific examiners in specific field of technology, working in specific field of technology, having specific expertise. So whenever you file an application, there is a central office which basically determines which field it would belong to and which examiner it would be assigned to. So it is always assigned to a subject matter expert who basically does the examination, and of course he is also a government employee and called a patent examiner within the patent office.
Okay. Ushav, actually we are overshooting the time.
Okay.
The answers will be clear. There is 3 more persons to be asked.
Okay.
So the next is Dr. Pal. Dr. Padas Pal, once more he has come. Yeah, Dr. Pal, very clear. We are overshooting the time.
I have more few questions. Actually, as we have got from many conversation, all types of inventions are not patentable in India. So basically, what are the types of invention which are not patentable in India? And another thing is that actually I am sharing this thing from my point of view. I have applied some patents. So they are asked after few months, they are asking for examination. So and in between this, they have published the patent journal. They have published the patent journal, but till the examinations are pending. Actually, what is this thing? I am not getting clearly. Actually, when the examination will be completed, and after completion of examination, obviously the patent will publish. But before that, the patent journal is published. They have given the patent journal number, and this is the thing.
Got it. Okay. So first thing is what is not patentable. So Section 3 of Indian Patent Act explicitly lists out a number of things which are not patentable. Few examples would be traditional knowledge, so knowledge which is already known to public, like maybe haldi, which or basmati rice or something that is already known to public, cannot be filed as a patent so easily. Second is how to play a game, how to suppose I have invented a new shot in a cricket, I cannot patent it. Third is mathematical models, formulas, business methods, a method of doing business. All of those things are not patentable. For pharmaceuticals, one of the very important section is section 3D, which says that if you have already patented a drug, doing mere changes in it, mere chemical formulation changes in it, to get the patent extended is not allowed. So such patents are not allowed unless you show substantial efficacy change to new molecules that you have developed over over your existing molecules. You cannot get a patent. Because this was a very standard practice done by various pharmaceutical companies, wherein you have a molecule that is patented, and when the 20 years dawns on and your patent is about to expire, you make some changes in it. You make some chemical formulation change and file for a new patent to extend the life of your patent. So that is not allowed. So these are the various things. You can basically go to Indian Patent Act section 3. You can get a number of such things which are not patented. Okay, atomic energy is something related to atomic energies, something that is relevant to government, other areas which is government is interested in. All of those things can be prevented from getting patented.
Okay, thank you. The last question is from Mr. Amir Sarkar. Please go ahead. Your
Hello, am I audible?
Yes, yes, sir.
Yes.
Yeah, thank you very much. I was listening, it was wonderful. I just got a question in my mind regarding cost implication of applying a patent. And second thing, is there any consultancy support who can help us while we file a patent? And third is, when you accept some experts to evaluate in your place, like reviewers in a paper, are they accepted from outside or by some application and getting a job in your office?
Okay, Utsav, let me give the answer.
Yeah, sure. Please.
Yeah, Mr. Sarkar, there is a group in the main techno campus of yours under Mr. Lakshmi Madam and Professor Kaur, Abhijit Kaur can let you know. So they are forming an IT cell, IT department, IT cell within the techno main campus, where you can get a one spot all the answers, all these things. So you can get connected with the cell. So after this session, after these 7 days, they will let you know that where to contact, how to contact, what are the processes and all this.
Okay. I have actually set 9 questions yesterday, and I gave that set of questions to your email ID, whichever they have forwarded, and next questions also I'll put there.
Okay.
Thank you very much.
Okay.
Okay.
So, Utsav, now go ahead and do the concluding part of your PPT, because there is no more time. We are overshooting the time.
Okay, so that's it for today. So today we basically discussed on what is patentable and what is not patentable, and what is the subject matter, what is obviousness, novelty. So tomorrow we would be having the session on anatomy of patent, and what are the advantages of filing a patent, why you should file a patent, and what is the monetary implication behind it. Some case studies, very interesting case studies on it. So I would request all of you to not miss tomorrow's session. Specifically, if you are an inventor, you want to file patents, please attend tomorrow's session. And actually, anatomy of a patent cannot be taught in a single session, in 1 hour session. It's not possible, but at least I can I can give you the precursors which you can have as a ready reckoner when you file as a patent, as an inventor, and you file a patent. So we will talk about that tomorrow, and some very interesting stories which I could not tell today because of shortage of time. Definitely try to squeeze them in tomorrow, but most important would be answering your questions, because that is what is, I feel, is most. So that's it for today. Tomorrow we should again come back. Jot down your questions, bombard me with questions. I would really like to help you guys out. Thank you.
Thank you so much, sir. It was a wonderful session we had. And I'm sure that whatever ideas or whatever queries that we had regarding patent, preliminary queries that we had regarding patent, that has been solved by this way. And it was wonderful hearing you for so long days. Thank you so much, sir. And I wish that in the coming 2 days, when we will have sessions with you, that is going to be much more interesting, and we will be able to gather more knowledge through this passage of time. Thank you everyone for joining. See you all tomorrow at 11 a.m. Thank you so much.
Thank you. Thank you, everyone.